Can you actually be charged with federal drug conspiracy if you never touched any drugs? The answer is yes, and it happens more often than most people think. I'm Michael Lowe, a criminal defense attorney in Dallas, Texas, and I've represented clients in federal drug conspiracy cases where they never personally handled, saw, or possessed a single gram of any controlled substance. Under 21 USC 846, the federal drug conspiracy statute, the crime is the agreement to violate federal drug laws, not the drugs themselves. Federal prosecutors do not have to prove you distributed anything. They do not have to prove you possessed anything. They just have to prove that you agreed with at least one other person to commit a drug offense and that you knowingly joined in that agreement. Today, I'm going to walk you through how this works, what the minimum conduct is for getting charged, why the penalties are so severe, even for people on the fringes, and what defenses are available. The first thing to understand is that drug conspiracy under 846 does not even require the government to prove what is called an overt act. The Supreme Court settled this in United States versus Shabani in 1994. The General Federal Conspiracy Statute 18371 requires the government to prove that at least one conspirator took some step to carry out the plan. Drug conspiracies have no such requirement. The agreement alone is the crime. That is a very low bar for federal prosecutors, and it is one of the reasons why conspiracy charges are so common in federal drug cases. So what is the minimum conduct that can get you charged? You need to agree to participate in a plan to violate federal drug laws while knowing of the general purpose of that plan. You do not need to know every detail. You do not need to know every person involved. You do not need to know the specific type or quantity of the drugs. And the government can prove this agreement through circumstantial evidence. That means phone records, text messages, surveillance footage, financial transactions, and the testimony of cooperating witnesses can all be used to show you're a part of that agreement. I have seen cases where lending a car, making introductions between people, allowing someone to use an apartment, counting money, acting as a lookout, or even just passing along a phone number was enough for federal prosecutors to charge someone with a conspiracy. None of those actions involve physically handling drugs, but every one of them can result in a conviction carrying the same penalties as if you had personally distributed the controlled substances yourself. There are limits. Mere presence at a location where drug activity is happening is not enough on its own. The Fifth Circuit pattern jury instruction makes that very clear. Simply knowing that someone you associate with is dealing drugs does not make you a co-conspirator. And a simple buyer-seller relationship standing alone is generally not enough to prove a conspiracy. The government has to prove you went beyond knowledge and actually agreed to participate. Here's where things get really dangerous for people who never touch drugs. Once you are found to be a member of a conspiracy, something called the Pinkerton liability kicks in. This comes from a 1946 Supreme Court case called Pinkerton versus United States. Under this doctrine, every member of a conspiracy can be responsible for every foreseeable crime committed by any other member of the conspiracy during the time they were involved. And in a drug case, that means the total drug quantity of the entire conspiracy can be attributed to you at sentencing. If the conspiracy moved 10 kilograms of cocaine over 2 years, and you were involved during that time frame, you could be sentenced based on those 10 kilograms, even if your only role was making a few phone calls. It goes beyond drug quantities too. If a co-conspirator carried a weapon during a drug deal, you could face a firearms enhancement. If someone died from the drugs the conspiracy distributed, you could face a 20-year mandatory minimum, even if you had nothing to do with that specific transaction. This is what makes federal drug conspiracy charges so dangerous for people on the fringes. Your personal conduct may have been minimal, but your sentencing exposure is calculated based on the entire scope of the conspiracy. The penalties for drug conspiracy are identical to the penalties for the underlying drug offense. For conspiracies involving 5 kilograms or more of cocaine, the mandatory minimum is 10 years and the maximum is life. For 500 grams of cocaine, the mandatory minimum is 5 years. If someone dies from drugs connected to the conspiracy, the mandatory minimum jumps to 20 years. Prior serious drug felony convictions can push a 10-year mandatory minimum to 15 years, and 2 or more priors can push it to 25 years. These are mandatory minimums, which means the judge cannot go below them in most cases. So what can you do to fight these charges? There are several defenses. First, you can challenge whether an agreement actually existed. Without proof of an agreement, there's no conspiracy. This is especially effective when the government's case relies heavily on cooperating witnesses who have a strong incentive to exaggerate or fabricate the roles of other defendants in exchange for their own reduced sentences. Second, there is a buyer-seller exception. If your only involvement was purchasing drugs for personal use, federal courts recognize that a simple buyer-seller relationship is not the same as a conspiracy. The government has to prove something beyond the purchase, like a stake in the resale, credit arrangements, or coordinated distribution activity. Third, if you joined a conspiracy but later left, you may have a withdrawal defense. But withdrawal requires more than just stopping participation. The Supreme Court ruled in Smith versus United States in 2013 that you have to take affirmative steps to disavow the conspiracy and communicate your exit to co-conspirators. Just not answering phone calls or moving away is not enough. And even a successful withdrawal defense does not erase your liability for the period before you withdrew. Finally, there are constitutional challenges. Conspiracy cases rely heavily on wiretaps, phone records, text messages, and surveillance. All of that evidence is subject to Fourth Amendment challenge. If a wiretap was not properly authorized, a search warrant was defective, the evidence can be suppressed. And in a conspiracy case, suppressing key evidence can collapse the government's ability to prove the agreement element entirely. For certain people who qualify, the safety valve provision under federal law can allow the judge to sentence below the mandatory minimum. And role reductions under the sentencing guidelines can decrease your offense level by 2 to 4 points, which can translate into years less prison time. If you are facing federal drug conspiracy charges in Texas, whether you're in Dallas, Fort Worth, anywhere in the state, or anywhere in the United States, these are serious charges that require immediate attention. I offer a free consultation to discuss your case. Call my office at 214-526-1900.